what we look for is we look for whatever it is that caused the accident. Can we make the argument that that's not a reasonably safe condition? That's the first thing. The second thing is, did the landlord know about it, or should the landlord have known about it? Okay? The legal term for that is called notice. There's actual notice, which is whether or not we can demonstrate that the landlord knew about the condition. And we can do that a number of ways. We can show that someone made a complaint about it. We can show that the landlord or someone employed by the landlord says that they knew about it. Okay? Or there's something called constructed notice. Constructed notice means we don't have to show that they actually knew about the condition, but we can show that they should have known about the condition. Okay? The most common way of doing that is by showing that the condition existed for a long time. If the condition existed for a long time, then the landlord or the landlord employees have an obligation to periodically look through the premises, maybe not every day, but certainly at some interval of time, and they have an obligation to discover defective conditions if they're there. So if we can show that that condition was there for anywhere, 30 days, a year, or whatever, and that the landlord didn't do anything about it, then we can show they had constructive notice of that condition, and they failed in their responsibility to adequately maintain their premises.